I would like to ask the other members of the panel. Mr. Barr, in the last impeachment, during the impeachment of President Clinton, repeated what was also said earlier today in terms of President Nixon in his comment. Quote, President Nixon was, when the president does it, that means it's not illegal. And Mr. Barr, to his credit, during the Clinton impeachment, his quote was, Nixon's statement, quote, was dead wrong then, and it is dead wrong today. Wrong, that is, unless one subscribes to the principle that the president is not only above the law, but that he is the law, end quote. The issue of refusing to appear before Congress, just that one count of impeachment, what is, in my mind, is that a, or I'm asking, is that a constitutional issue or a policy issue? And what justification can there possibly be to the degree that the president has employed this tactic to justify its use in the context that this president has done so? Please, Mr. Anderson.
Well, it's clearly a constitutional issue. It's not just a matter of policy. And it goes right to the core of our constitutional system. It's up to Congress as to whether its power is going to slip through its fingers. And now is the time to assert Congress's power. It's not waiting for the goodwill of another president, hoping that they will restrain themselves. It is up to Congress. And, you know, it's unbelievable in this body how people have cavalierly downplayed the abuses of power that go far beyond what was talked about during the Nixon impeachment, which, by the way, they didn't end in the articles of impeachment. They weren't talking about criminal offenses per se. They were talking about abuses and breaches of trust and subversion of constitutional government. Here, it is absolutely unprecedented. It's not a matter of whether you like it or not. It's not a matter of policy. It has been a matter of egregious violations of domestic statutory law, laws passed by this Congress, treaties that have been ratified by the Senate, and the Constitution. We're talking about violations of those laws that prohibit torture, the indefinite detention of American citizens with no due process, no lawyers, no trials, no charges against them, absolutely unprecedented. Kidnapping, disappearing, and torturing people around the world, and then the FISA violations, which, again, they want to be downplaying those, saying, well, other people have caused the warrantless wiretapping of this sort. Never has a president, in engaging in warrantless wiretapping, before violated the terms of FISA, which provide that every instance is a felony. These blatant violations of law.
I think Mr. Fein would like to ask that. I'd just like to add, if you include in what Attorney General Mukasey has come before this committee and said blanketly, we refuse to honor the congressional subpoenas that you issue.
That by itself, in my judgment, is a clear impeachable offense. The Founding Fathers understood the most important function of Congress is the informing function, that self-government can't work unless the people know what their rulers are doing and why. And that can't happen if they don't appear before Congress. The president doesn't voluntarily disclose things. And simply by refusing even to appear, it's the equivalent of contempt of court, like refusing to obey a court order, which I think everyone would concede would be an impeachable offense. I think that's one of the things that that question points out, Congressman, is that I don't think you would need a very long period of time to decide whether what the president has done is an impeachable offense. It's open, it's notorious, you just vote. You just need to know what the Constitution means. The facts are on their face, contemptuous of this legislative body.
Thank you. Ms. Holtzman?
Congressman Wexler, I think if you take the constitutional standard for impeachment, what is a high crime and misdemeanor? Mr. Mason said that it was subverting great and dangerous offenses that subvert the Constitution. Subverting the Constitution here is when the president for no reason, not even a colorable claim, refuses to give Congress the information it needs to do its job and obstructs the work of Congress. That can be an impeachable offense. If you translate it in an impeachment inquiry, in other words, if you were to commence an impeachment inquiry, and then you were to ask the President to provide the information again, the obstruction of an impeachment inquiry, the failure to cooperate with an impeachment inquiry, the failure to provide the information, is itself an impeachable offense, as we established in the Nixon proceedings and in the Nixon precedent. So these are very serious. And because what the inquiry, if you go back, what were you asking about? You were asking about whether the Justice Department undermined the rule of law by engaging either in improper prosecutions or by firing people because they refused to engage in improper prosecutions.
Thank you, Mr. Chairman. My time has long expired. Thank you very much.
Steve Cohen.
Thank you, Mr. Chairman. Congressman Holtzman, you suggested that you think there's a prima facie case for impeachment of the President. Is that correct?
Well, I'm not allowed to say those last two words.
Prima facie
I get to say 14 of the 16 words, but the last two I can't say.
I feel like George Carlin's words or something.
Why don't we say high government, high administration officials, yes.
Would that include somebody who was considered to be not a member of the executive but a barnacle attached to the legislative branch?
Such as?
Such as the man who would succeed to the office of president if he got out of the...
Oh, I think you can do a twofer.
They could be a twofer. Mm-hmm. But if that person was assigned to the legislative branch, could you impeach him? Is a person who's assigned to the legislative branch attached, as Mr. Addington has said the vice president is, would he then not be subject to impeachment?
No, I don't know what Mr. Addington says about that, but there's no question the vice president could be impeached.
But he'd have to be a member of the executive branch to be impeached, would he not?
I think there's some, maybe Mr. Fein knows this, but I think there's also some precedent for holding that members of the congressional branch can be impeached as well.
The very first impeachment was against a senator, Senator William Blount of the Senate. As the standard has clearly been established that members of Congress can be impeached.
Thank you. I was trying to see if there was some method to their madness. We had General Mukasey before us this week, and he said that the vice president is obviously and definitely a member of the executive branch. And the previous week, Mr. Addington said, no, he's not, or he could be, and he went back to Katzenbach in 1961, some opinion, and suggested he was attached to the legislative branch, so he was neither. He wasn't really an executive. And of course, the National Archives wanted him to classify papers. They're not part of the executive. So I guess there's not a method to their madness. They're just madness.
Right.
Yeah. Well, it's very clear the vice president has claimed he stands in the shoes of the president when he claims immunity from suit. That he argued in the suit brought by Valerie Plame and Mr. Wilson following the disclosure that he was entitled, like the president, to absolute immunity. So he claimed he was an executive officer there, and obviously when he refused to respond to the request, I think it was by Mr. Berman's, I think it's Mr. Berman's.
Maybe Waxman.
Mr. Waxman's request for documentation of the statements he had made to the special prosecutor in the Valerie Plame investigation. It was executive privilege of the president that he claimed. Now, maybe that destroys their idea of a unitary executive, because now that sounds like a duumvirate under the Roman Empire, but I doubt whether they were thinking of that analogy.
Mr. Fein, when you did the research, I know, on General Gonzalez, did you feel like there was a prima facie case for some type of impeachment proceeding at that time?
Well, I think there needed to be more investigation of the facts as to whether or not during his testimony he had misled Congress as to what he knew about the reasons for the firing of the U.S. attorneys, communications he had had with the White House or otherwise. But certainly if that could be established, obstruction of a congressional investigation surely would rise to the standard of a high crime and misdemeanor.